The Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own individual personal digital devices. So also please note that due to matters entirely outside our control, for instance, the time that Spectrum decided to do work on my street a few months ago, there's occasional disruptions to connectivity that may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know and be patient as we try to restore the audiovisual signals to effectively conduct business during the pandemic. For members of the public who are participating by telephone, and when I indicate during periods for public testimony that public testimony is allowed, you can use the key sequence *9 to raise your hand and *6 to ask to be muted. My name is Jonathan Lee K.K. Scheuer, and I have the honor of currently serving as the State Land Use Commission Chair. Along with me, Commissioners Axon, Chang, Okuda, and Wong, our LUC Executive Officer Dan Oradenker, Chief Planner Scott Derrickson, our Chief Clerk Riley Hakoda, our Deputy Attorney General of the week Linda Chow, Program Specialist Natasha Quinones, and the court reporter Jean McManus are all on the island of Oahu. Commissioner Cabral is on Hawaii Island, Commissioner Ohigashi is on Maui, and Commissioner Giovanni is on Kauai. We currently have 8 seated members of a possible 9. We're now going to move to our next agenda item, which we deferred yesterday, the City and County of Honolulu's Important Agricultural Lands Designation matter. Mr. Hakoda or Mr. Derrickson, is there public testimony on this matter?
Mr. Chair, is from the Department of Agriculture, State of Hawaii, and also from the State Office of Planning. And those have been posted to the website.
On top of this agenda, that's wrong.
Did the representative from, this is an overview briefing from Mr. Oradenker, but did the representative from the Department of Agriculture wish to, I suppose Mr. Yamamoto, did you wish to provide testimony at this time?
Right now, beyond what Earl Yamamoto, Department of Agriculture planner, giving testimony right now, beyond what we have submitted in writing, I don't have anything prepared to say orally.
Okay, that's fine. Thank you. And sorry, Mr. Hakoda, you also indicated OP had filed on this matter.
Yes, Mr. Chair.
Okay, so this is this meeting, this portion of our meeting is a briefing. It's not a action item. We're going to be briefed by Mr. Oradenker on this. So normally, procedurally, right, we hear from parties and then OP weighs in, but I'm going to offer the opportunity to the OP to offer any testimony given the nature of this agenda item. OP?
I believe as this process is moving forward, our comments might be better addressed at a later time.
Okay. Thank you very much, Mr. Yee. With that, then, I'm going to turn it over to Mr. Oradenker to give his presentation.
Thank you, Mr. Chair. The reason that
excuse me, Dan, I'm going to interrupt. I didn't ask for any other members of the public. I apologize. Are there any other members of the public who are participating in this meeting via the attendee function in the Zoom meeting who wish to testify on this matter? If so, please use the raise hand function or click *9 on your phone if you're calling it. Is there anybody in the public who wishes to testify on this matter? Seeing none, I apologize for my mistake and the interruption. Mr. Oradenker, please proceed.
Thank you, Mr. Chair. What's got us here today is a county submittal, City and County of Honolulu submittal under section 205-47 of the Hawaii Administrative Rules, identification of important agricultural lands, county process. And as we have never received a submittal from a county under 205-47 prior to this, staff thought it would be good for us to brief the commissioners on how we are to view and handle a county submittal. And our intention is to kind of go through the law and how staff perceives those things should be, the law should be applied and the rules should be applied to handle this submittal. I would caution the commissioners once again, and we're going to screen share here with a PowerPoint presentation that is also available for the public and anyone else at our offices if requested. I would caution the commissioners and the county, NOP, and DOA to look at this matter a little bit differently than a private sector submittal. And what I mean by that, and we'll see as I go through this, is that under a private sector submittal, by the time the matter comes before the commission, staff and the private sector landowners have ensured that the proper process was followed in making the submittal. And the requirements for a private sector submittal are not that much different from any other petition by a private landowner. The county submittal, on the other hand, is quite different. County designations.
Touch the screen.
Okay, hold on. We're having a little few technical difficulties here. There we go. Okay, I got it now. Wrong button. County designations are governed by section 205-47 to 49 of the Hawaii Revised Statutes. And the rules governing the process are set forth in sections 15-125 and 15-126 Hawaii Administrative Rules. Under section 205-47 HRS, the counties submit to the LUC proposed designation of lands within the county that are appropriate for IAL designation. One of the key words here is proposed, and as you'll see as we go through this, what the county has submitted is really a recommendation, and we have to view it as such. And the reason that we've only had one of these is the counties have viewed this as an unfunded mandate, and as a result, they have not been anxious to perform the process to designate IAL lands within the counties. And as you'll see, this is quite involved and takes quite a bit of effort. There is a requirement that the counties and that the counties submit their proposals within a certain time. Whether or not that time is run is unclear, and I'm not sure it is actually applicable at this stage. There is the potential, though, that, and the commission should be aware of this, that someone could object that these submissions are untimely. Section 205-9 provides a limitation on the power by the counties to designate lands or to recommend designation of lands within their county. If a landowner has already voluntarily designated more than half of its land important agricultural land, the county may not designate any more of the landowner's land IAL under section 205-47, the county process. And that is why, commissioners, that we've seen so many private sector submittals on important agricultural lands. And it's because a lot of large landowners in particular felt that they wanted to be in control over which of their lands would be designated IAL and which would not. So there was a scramble at first to designate lands before the counties could do their designation. Now, let's dig down a little bit deeper into 20547, which contains the process for the county planning departments in designation. And this process is not simply an examination of the land in the county in relation to the 20544 criteria that we're all familiar with in important agricultural land designations. Part of what's important for the Land Use Commission to ensure that the counties have done is they must follow all of these other requirements in assembling their recommendation. There must be notice to all the landowners whose lands may be subject to examination for inclusion. They have to undertake a public outreach program prior to reaching their conclusions. They have to develop a matrix setting forth how the criteria for designation are applied. Then they can develop maps, and then they can go to the obtain county council approval of what they've done. And then they must submit a complete record of the proceedings and methodology that they use to the Land Use Commission. If the county doesn't follow this process, I believe that a submittal can be rejected as insufficient or flawed. And part of what the commission's responsibility is to examine the process that the county used to see if it met the criteria of 20547. In more detail, 20547A requires the county to identify and map potential IL lands based on the criteria contained in 20544. That we're all familiar with. We've worked with 20544 before. Section B requires that the maps be developed, and this is where the public participation is important, as well as other agencies, in consultation and cooperation with landowners, the Department of Agriculture, agricultural interest groups, including representatives from the Hawaii Farm Bureau Federation and other agricultural organizations, the United States Department of Agriculture, Natural Resources Conservation Service, the Office of Planning, and other groups as necessary. So the minimum that they had to have consulted with are those listed, and based on what they've uncovered, other groups as necessary. So kind of creating a specific and a non-specific requirement for them to discuss the matter with various members of the community. Because I'm too focused. Section 20547C sets forth a number of very specific and wide-ranging requirements for public meetings and outreach that must be undertaken by the county planning departments and must be identified in their submittal. And once again, this goes back to the additional scrutiny that the Land Use Commission has to undertake in looking at a county submittal. Each county, through its planning department, should develop an inclusive process for public involvement. So there has to be some evidence that a process was developed, including a series of public meetings throughout the identification and mapping process. Again, there must be evidence of public meetings. The planning departments may also establish one or more citizens advisory committees on important agricultural lands to develop further public input, utilize an existing process such as the general plans, development plans, or community plans. Once again, this section sort of lays out a specific and non-specific process. And this is where some of the Land Use Commission's discretion comes into play with regard to whether or not the county process was sufficient. By the way, commissioners, if there's any questions, I don't mind taking them in the course of my discussion rather than waiting till the end. 20547D requires notice. The county has to notify all the landowners of the process, not just that they're doing it, but what the process is, and requires them to take into account lands that have already been designated IAL, as we previously discussed. It also sets forth the basic criteria for making a determination on what lands should be designated IAL. And once again, I keep emphasizing this. This is to develop a recommendation that goes to the Land Use Commission. In formulating its final recommendations, once again, the words recommendations is used, to the respective county councils, the planning department shall report on the manner in which the important agricultural lands mapping relates to, supports, and is consistent with the standard and criteria set forth in 205-44, counties adopted land use plans, comments received from government agencies and others identified in subsection B, the viability of existing agribusiness, and representations or position statements of the owners. Whether or not any one of the criteria, it also requires the county department to submit its findings for approval of the county council, by the way. Whether or not any one of the criteria is paramount is unclear, but the county must address why or why not it used or did not use each of these criteria. So it's not that the county has to give equal weight to all of these. As with 205-44, it can be a weighted examination. And in other words, one of the most common ways we've seen this done is that various criteria are given various numerical scores, and then in the end, everything is all added up and a baseline is met. Unlike the private sector process where we're just determining whether or not the lands proposed to be designated meet the criteria set in 205-44, one of the questions that the commission has to examine is, has the county adhered to all of the requirements of section 205-47 in developing its maps and in its submittal? This includes both procedural and substantive requirements. So the county has to show that it met with all the required community groups and agencies and noticed all the interested parties. And it also has to be completely transparent on what criteria and methodology it used to apply the criteria in 205-44, and that it applied those criteria in an objective manner to reach its final conclusions and ultimate determinations. Section 205-44, just to refresh everybody's memory, contains the criteria for the identification of important agricultural lands, and they're listed here in 205-44. I've crossed out section B because we're not operating under B because this is a county submittal and it's not a declaratory order submitted under 205-45 by a private landowner. There is some flexibility, and this is where the counties can exercise a lot of discretion in determining what criteria are most important. And counties are supposed to have developed matrices to indicate how they applied the criteria and what weight they give to the various criteria in 205-44. Once again, not all the criteria have to be met. Weighing the standards and criteria with each other to meet the constitutional mandate proposed in Article 11, Section 3 of the state constitution is the ultimate goal. A weighted system is encouraged that gives different numerical values that can be added up and used to see if a land qualifies for designation. In reviewing the county submittal, it is therefore key to examine what criteria were used in the process and whether they were applied in an even-handed manner to the parcels identified as the ones to be designated. That doesn't mean there can't be exceptions. The only precautionary note to that is that if there is an exception and a land is selected for designation for some reason, they have to explain exactly why there was an exception made, and the commission has to determine if they were reasonable. Those reasons for an exception were reasonable and not arbitrary. Section 205-48 sets forth the procedure necessary for the Land Use Commission to process a county submittal. They have to submit their maps to the Land Use Commission, and OP and DOA must comment and make recommendations. 205-48C is then a reiteration of the criteria that must be applied, but this time it's directed at the state, the Land Use Commission, for review. So this is where you begin to see the intention of the statute was to provide the LUC with the ability to do a de novo review of the county's process and decision-making. 205-49 really gives, this section as well as 205-49 really gives the LUC the power to make its own determination on whether the county properly applied the criteria and whether or not all or part of the designation was legitimate. 205-49, Commission's designation of IAL. After we received the maps and the recommendations of the Department of Agriculture and the Office of Planning, along with all of the other information that was utilized by the Department of Planning to develop those maps, the commission shall then proceed to identify and designate an important agricultural land subject to section 205-45. This section clarifies that it's the responsibility of the commission to actually designate, and the county submittal is a recommendation, the start of a process that the commission must complete based on its own analysis of the evidence before it. So the submittal by the county is not actually the designation. The commission, again, the submission by the county is a recommendation, and the Land Use Commission is empowered to adjust, deny, or approve that recommendation in its entirety based on the evidence before it. 205-49A criteria. Once again, this is the only reason that this is up is that we are again seeing that the county submittal is actually classified as a recommendation. To 205-49A, again, any decision regarding the designation of land as important agricultural lands has to be based upon written findings of facts and conclusions of law presented at least one public hearing conducted in the county where the land is where the land is located in accordance with Chapter 91. One of the other things here is that the approval must be by 2/3 of the membership, which the commission is entitled. So this is similar to a DBA. It's not a simple majority. In our case, we need at least 6 votes to approve. And now we can turn to our rules a little bit with regard to county submittals. Subchapter 14 of section 15-15 deals with important agricultural lands. 15, 15, 125, and 126 are the specific rules that govern the designation of IAL under the county identification process.
Hey, Dan, this is Gary. Before you move on to that, can I ask a question? Since you're
Sure.
moving on? Yeah, this deals with the decision-making process. What's the standard of review that we would apply? In other words, what level of deference are we to give to the county in making its decision? Because, you know, like when I look at 205-47 parent E, right, which that section says, the important agricultural lands maps shall be submitted to the county council for decision-making. The county council shall adopt the maps with or without changes by resolution. The adopted maps shall be transmitted to the Land Use Commission for further action pursuant to section 205-48. yeah, the language about recommendations and things like that, you're correct, it's in the statute. But a lot of the criteria in 205-47 precedes this subparagraph E. And so the reason why I'm asking the question is you have all of these things submitted to the county council. The county council, who are the elected representatives of the county, make a decision. I mean, where in the statute or the case law does it say that we're not supposed to give deference to the county council?
Well, first of all, I think we all have to recognize that, to be kind, this was a very poorly drafted piece of legislation.
Yeah, I agree, and and I'm not trying to.
To answer your question to a certain extent, Commissioner Okuda, the problem with that paragraph E in 205-47 is then if you go to 205-49A, it again talks about designation. It says after the receipt of the maps of eligible important agricultural lands from the counties and the recommendations of the Department of Agriculture and the office, the commission then proceed to identify and designate important agricultural lands. The kind of theme that runs through this whole thing is that it's recommendations. From a practical standpoint, I think that as we are not the fact assembling body, or we haven't done our own fact finding on this, that we're relying on the counties to do the fact finding, that there's a significant amount of deference that we should be given to the county's recommendations. But there's no case law on it. I mean, this is the first time that we've ever looked at one of these. So,
yeah, well, Dan, I only raised that because, although I know we all try to do our jobs diligently, the county council is the elected body of the citizens. And so, if that sentence was, or this section 205-47E wasn't in the statute, in other words, if there wasn't a provision for submission to a county council, and it says for decision making, right? And there wasn't a specific decision making by resolution, which is something that has the force of law. Well, then I could see less discretion being given to the county planning department. But where you have a legislative body elected by the citizens, making a decision that this apparently should be the public policy of the county. What kind of deference are we supposed to give to the county council, and what authority do we have not to give deference? I'm not saying we ignore all evaluation, but it's a question of, to what extent should we not be giving deference to what the elected people have rendered, whether we like it or not. Yeah.
Well, I feel the best way for me to answer that question is, to be perfectly honest, I don't know. I think that's something that the commissioners should discuss during the hearing process and vote their conscience on it. I can say, though, that part of the reason, if you go back to the legislative history, part of the reason that it was set up this way was, to a certain extent, to remove politics from the ultimate decision. And that's why the Land Use Commission is the final arbiter of the discussion, I believe. But that's just my opinion. I don't know the answer, Gary. I honestly don't. The statute is unclear. We're trying to figure our way through this. Once again, I believe, personally, it depends on the severity of the evidence that the county council has made a mistake. I don't think that you'll see staff. staff is not going to redo what the county did. So for all intents and purposes, we are giving them a lot of deference. I think that one of the things that we're trying to convey, that staff is trying to convey with regard to this, is that our primary burden, our first threshold is to see whether the county actually adhered to the proper process, the county planning departments. Assuming that they did, and there's no evidence to indicate that there's some fault with their recommendations, I'm not sure staff would recommend varying from it very much at all. And I was gonna discuss this in a minute or two. The question is whether any of the landowners are gonna come in and object.
And I acknowledge a hand raised by Commissioner Ohigashi as well.
Process is legitimate. Anyway.
Okay, thank you. You and I can write a law review article on this portion later on after we all retire.
Okay, sounds, that works for me.
And it will be read by the members of this call and no one else. Commissioner Ohigashi, followed by Commissioner Giovanni.
Yeah, I'm concerned about that these are recommendations, and your comment that essentially we can review them de novo. Does that mean that if, maybe I'm getting ahead of myself, if landowners come in and object, that it will be essentially an intervenor contested case process? Because it would seem like our decision would affect the agriculture or the property rights of that individual landowner and elevate this process, it seems to me, into some sort of contested case.
Well, that's actually a very good question and something that I was going to address further on in the discussion. The answer to your question is probably yes. I mean, even though the rules don't set out, the statute doesn't set that out. The rules actually provide for this to be a rulemaking process rather than a declaratory ruling. And under those circumstances, a landowner has the right to bring in evidence, data, and make its case with regard to, in this case, what we're going to call a rule. Whether that elevates itself to the level of a contested case hearing is, by law, is questionable. I would think that this commission would want to give landowners an opportunity to have due process and have their position fully heard and fleshed out, and it is not outside of the boundaries of this commission to hold a quasi judicial process to handle that. I mean, I think the commission could do that if it so chose. Landowners who object are not technically not interveners, as this is not a district boundary amendment proceeding. And the statute lays out that it's either a declaratory ruling or a rulemaking in this case. So technically there's no right to intervention, but I would be recalcitrant if I did not say that it's my opinion that due process would require that we give every landowner who has a concern a full hearing on this.
Okay, Commissioner Higashi, did you have a follow-up? Otherwise, it's Commissioner Giovanni, followed by Wong, followed by our Deputy Attorney General.
I just had a comment. It would mean that there is a potential for multiple landowners to object to the designation. And if we are required to give them due process, it may require us to spend years on one particular designation.
Well,
I mean,
yeah.
we have, I know we have 365 days, but
Yeah.
that's all. Anyway.
Yeah, staff is aware of that, and that's why we have so many days scheduled for hearings on this. I mean, I'm not sure how long it will take us to get through various landowner objections, but
And
to be honest with you, Chair, I mean, Commissioner Ohigashi, it kind of is what it is.
one last question is that, assuming that the commission wants to move a line, saying, well, it should be a little bit over here to the left, the line. It's a recommendation. And we say, and that's what we want to do. Do we have to refer it back to
I'm,
councils, or do we have that ability, since it's only a recommendation, to actually move lines on any kind of?
I think that that's up to the commission. I think you do have I believe that there's a very strong argument that you do have the ability to move the lines. But if the commission is uncomfortable with that, it can send the matter back to the counties for re-review based on the evidence that it received.
Okay, I'm going to call on Commissioner Giovanni, followed by Wong, followed by Deputy Attorney General.
So Dan, in this slide that you have up, it refers to a public hearing conducted in the county.
Yeah,
Does it have to be a physical hearing, or can it be by a virtual meeting like we're having these days?
well, I don't know, that's actually a question for the Attorney General. I mean, all our DBA hearings are supposed to be in the county where the land is, so I'm assuming for the moment that the governor's emergency proclamation covers this process as well as the DBA process.
Fair
So
enough.
we could be held it by Zoom.
That's all.
Thank you, Commissioner Giovanni. Commissioner Wong?
Thank you, Chair. So the question I have, following up with Commissioner Ohigashi, I was assuming that there is a timeline on this as for a year or X amount of days to do this IAL.
365 days, yeah.
So the following up on yours and Commissioner Ohigashi's statement of if an individual landowner comes aboard and contests it, do we take each case individually, and how would that change the timeline?
Well, once again, that's at the discretion of the commission. Staff is prepared to take, and I think that we would have to at least give each landowner the ability to put on their case. So to a certain extent, you are taking each parcel individually if there's an objection. The final determination can be at a single hearing, I believe, but we do have to give every landowner the opportunity to make their case.
Okay, so following again, I'm following on Commissioner Ohigashi. So let's just say we finish all the landowners and do everything and package it back up.
Yeah.
And we do give it back to the county saying we're moving the line X left or right. Does that come into our timeline too? Or does it like stops the clock?
We have to make a final determination within 365 days with the ability for 180 days extension at the discretion of the chair.
And the other question I have is, if I remember our IAL language, we can accept, modify, doing, and deny, correct?
Yes.
Okay, that's all. Thank you, Chair. Thank you, Exo.
Ms. Chow?
So I think some of the questions being raised by the commissioners is answered by the statutory provision that's on the screen right now, 205-49A. So when the underlying portion says it's to be done, the decision to be done by written findings of fact and conclusion of law. Generally, findings of fact and conclusion of law are not done in connection with
Ms.
rulemaking.
Chow, it's hard to hear you. There's something
Okay.
with your microphone.
And let me try putting both headphones in. Is that any better now?
Not really. It's about the same.
Okay. Let me try my audio settings.
You, however, do not appear to be a cat.
Okay, well, that's good. How's this? Any better?
Just
No?
proceed, but just know that it's soft.
Okay, I apologize for that. So the provision that's on the screen right now talks about written findings of fact and conclusions of law that the commission has to make in connection with any decision it makes. That would tend to indicate that the decision is more of a declaratory order rather than as a rulemaking type procedure. But ultimately, the decision that is to be made by the commission, according to the statute, is that the subject lands meet the standards and criteria set forth in 205-44. And so I think this would indicate that it is a de novo review by the commission because you ultimately need to make the decision that it meets the standards and criteria. To the degree where individual landowners challenge their inclusion in the IAL designation, it's up to the commission to decide whether or not those particular lands meet the standards and criteria, and on that basis would be included or not be included in the designation.
Thank you, Ms. Chow. Are there other questions at this time, or should we ask Mr. Ordenker to proceed? Why don't you proceed, Dan?
Thank you, Chair. Okay, with regard to our rules, once again, 1515-125 and 1515-126 governs the county identification process. And for the most part, the rules track Chapter 205. And if the rules are confusing or they don't track 205, you're looking at the guy who wrote them, so feel free to beat up on me. 1515-125A is once again a reiteration of the timing.
The chair will note we never wait for that invitation.
Well, I'm just telling you that I wore my, my flak suit today. Okay, so this is where the 365 days and the 180-day extension are set forth in our rules. It also sets forth that it's the county's obligation to submit a complete record of their proceedings to the commission. And I would note for any county representatives that we hope that was done and that we are relying on the county to make its case at any hearings that are held on this matter. 125B sets forth the requirements of the submittal. One of the keys, again, in this is that we require the county to submit an evidence that it has utilized an inclusive process for public involvement in the identification of potential lands and the development of maps. When we drafted the rules, we wanted to reiterate that this is an inclusive process and not something that was done by the counties without public input. Again, Section 4, they have to show us evidence that they've taken reasonable action to notify each owner of those lands by mail or posted notice, and evidence that the agricultural lands mapping relates to, supports, and it's consistent with the same criteria that are set forth in the statute. In other words, the 205-44 criteria, that their adopted land use plans adhere to that process or are consistent with that process, that they've received comments from government agencies and the others identified in 47B. And again, the viability of existing agribusiness and the representation of our position statements of the owners whose lands are subject to the potential designation and any other relevant information. Just based on anecdotal evidence, the county, in this case, the county has at least received comments and position statements from the owners whose lands are subject to the potential designation. When the county was going through this process, we were contacted by a significant number of landowners asking us questions about the process. And I would think that any landowners who received the proper notice had the opportunity to comment, but that has to be determined in the course of the proceedings before us, in the course of the proceedings before us. Now, 1515-125D is kind of interesting because it defines the process as modified rulemaking. 1515-125 says this specifically provides that the proceeding will be conducted as rulemaking under 1515-109. And 1515-109 sets forth a process that has safeguards in it to allow landowners to make their case. Specifically, the witness may submit testimony and shall be given a reasonable opportunity to present testimony. Section E in particular provides that all interested persons shall be afforded an opportunity to submit data, views, or arguments orally or in writing. This can be done up to 10 days after the close of the hearing, which is kind of interesting. So we theoretically could hold a hearing and then for 10 days not know whether we have to hold another one. We will be scheduling accordingly. If we do not see any evidence that someone wishes to submit arguments and requests a hearing, within that 10-day period, we will then schedule for decision-making and further deliberation. But we'll talk about process in a minute, but the intention is that the commission will hear the county and DOA and OP and then not render a decision at the conclusion of those presentations, but give the landowners the time to submit a request or submit arguments up to 10 days afterwards. And this was discussed earlier. What are the commission's options in rendering a decision under 1515-125? The commission may remand the matter back to the county for further review or clarification, adopt the recommendations in the county in its entirety, or based on evidence presented, amend or revise the county recommendation and proposal to exclude or include certain lands from designation as important agricultural lands. This is not all that different from a special permit that we received from the county in actuality. Those three options are available to the commissioners with a special permit, although the last section, section 3, with a special permit is limited in that we can, add conditions to a special permit, but we can't completely revise the county recommendations. So this is a familiar process to the commission. What all this means in application. So what's going to happen from here is that we will be scheduling a hearing, and it's already on the calendar, to make its case that has met the requirements of Chapter 205 and making its recommendations. The LUC has the obligation during the course of that hearing to examine the county submittal and any oral testimony to ensure that there has been adherence to the procedural and substantive requirements. OP and DOA will also be given an opportunity to respond and present their positions. And because these are rulemaking proceedings, interested parties will have to be given a reasonable opportunity to testify and have the right to submit data, views, and arguments. And once again, technically, this is not a right to intervention. So what we will do, we will schedule and hold an initial hearing to allow public testimony and the county to make its presentation and case, and for OP and DOA to present their positions. Then we will not render a decision at the end of those presentations. And we will entertain requests by landowners or interested parties for a period of up to 10 days afterward to make a presentation and submit evidence to support their position. If we receive such requests, the LUC staff will then schedule a quote unquote hearing date for those requests to be heard and decided upon. And once we have heard all of that evidence, the LUC will schedule another hearing to allow for a final decision on the county recommendations and the maps provided. After that, a written decision in order, findings of fact and conclusions of law will be prepared and another meeting scheduled for its adoption. And that is all I have at the moment. If there are any questions or any discussion.
Okay, I'm going to first acknowledge that there's a question that's put into the question and answer period. And this is a somewhat funky thing that is an artifact of us having a virtual meeting. We're in a formal public meeting right now. Normally, a member of the public wouldn't be able to suddenly intervene in the deliberations that the commission is having and ask a question. It's sort of the digital equivalent of standing up in the back of the room and kind of like, hey, what about this? And I don't know that there's a Zoom way to turn it off or if it's appropriate to. That said, we recognize there's interest and concern on the subject. I would encourage the person with the question to directly call the LUC office and reach out, and I can also ask the LUC staff to respond in the Q&A with the appropriate contact information. Having said that, I'm going to call on Commissioner Chang. Hi, Don.
Thank you, Mr. Chair. Thank you. Dan, I've got a question about the procedural steps that you provided us. So do we know how the city is going to present their IAL this matter? Is it going to be by the various districts so that community members will attend? Yeah, I don't know how long this is going to take, and I'm just wondering if we're taking public comments. Is the community going to have to attend every meeting to ensure that the particular area that they live in and the property that's being designated is going to be, that they have an opportunity to participate in that?
That's a very good question, Commissioner Chang. We don't know exactly how the county is planning on presenting their case with regard to this. I would strongly urge any commissioners who have any thoughts or concerns to contact or to express them here rather. And staff will then make every effort to discuss the matter with the county to expedite the proceedings.
Okay, and do you know whether the county is going to present to us as evidence all of the community comments and any, especially notifications from landowners, and whether landowners participated in both their community outreach process as well as the planning commission process? I just want to ensure that we are hearing, that they've been given due process both at the county level as well as at our level.
Understood, Commissioner, and I think that's one of the obligations of the commission. That information is actually contained in the submittal, in the written submittal. So we will, that's available for review, and we will be, staff will also be reviewing that as well.
Okay, so I will expect the county that when they do their presentation, that there is reference to the record below on when they're going through the various areas, identifying, especially in particular, landowners' comments and their participation. Thank you. I don't have any other questions.
Thank you, Commissioner Chang. Commissioner Ohigashi.
We're going to schedule a meeting with the counties to go through some of this.
We can hear you, Dan.
I'm sorry.
And I still am kind of concerned. The legislature has designated this as a rulemaking process as well as our rules and regulation. However, because we're an administrative agency, we're governed by the APA. And my recollection is that a contested case there's a definition of what a contested case is in that. And just because you label it a rulemaking process does not mean necessarily that it is covered under rulemaking. It is definition in the APA that rules whether or not it's a contested case. So my concern is that if we are to proceed on the rulemaking process, we get our Deputy Attorney General to render us an opinion that this is not a contested case and that it's strictly rulemaking, that we will not have to offer, for example, landowners the opportunity to test the evidence that was presented before the county councils or before the planning commission. It would seem to me that if they're allowed to call witnesses to bolster their opinion and the record, are those witnesses going to be expert witnesses? Do we limit them to the 3-minute rule? If they're going to do any kind of real due process, they're going to have to do that. And who gets to cross-examine these witnesses? And whether or not they're allowed to test it, and going back to my first statement, whether or not they're allowed to test the evidence given to the planning commission or the county council. And those are my concerns.
They're legitimate concerns, Commissioner Ohigashi, and they almost mirror my conversation that I had with House leadership at the time that this was moving. And the response, and I will never forget it, that I got from Senate leadership on that particular day was literally a shrug. So I think that the message to that back then, and I was not, I was representing a landowner back in those days. I was not representing the Land Use Commission. I think the answer to your question is that we have to use our best efforts, our best conscience, and the advice of counsel to determine how we are to handle this, because it has not been tested. It's unclear. And once again, I would remind everyone that the legislative history on this is that on the floor, when Ezra Kanoho was urging passage of this bill, he recognized that the bill was flawed and that it would need to come back to the legislature to be fixed, which they never did.
Commissioners. Commissioner Cabral.
Thank you, Chair. And I read all of the data that came, including that, I thought, very informative letter that was sent from Department of Agriculture, I think yesterday we got. And I had a couple of questions when I read all of it. First off, especially in the slideshow that we just went through, I read all of those 23 screens the other night. And there's clearly a lot of conflict. It's, you know, I mean, I was even aware of it. And then of course, some of it's pointed out that there's, you know, uncertainty on it. So it's really terrifying to think that we're going to enter into making these decisions when the county is going to propose land, which is in some ways almost a matter of taking of land. You know, when the county, when a private owner brings it to us, that's their decision. I know they're possibly being motivated for protecting of their other lands. So they've got, because of that incentive of the no more than 50%. But when the county presents it, it's almost a matter of taking. And I think we're going to find a lot of problems. So I'm glad to hear that Dan and the staff are so working on trying to make sure our process is clear. But I also had a really big question. It seems like if the lands that have been designated, I guess that's Honolulu, some of them are as small as 2 acres. So there's no size limitation on what could be, the county could bring forward that they would want to put in designated land. Is that correct?
Okay, I'm going to ask Dan to respond to this question. I recognize at least Commissioner Chang has a question, but I'm going to call for a break after Dan's response.
Thank you, Mr. Chair. Thank you, Commissioner Cabral. First of all, I would like to emphasize that, and once again, I don't mean to overstep my bounds with regard to this, that the classification of this as a taking is a little extreme. Once again, important agricultural land designation is more of a planning process. It does not change the rights or ability of a landowner with regard to existing agricultural land. So saying it's a taking is a little, maybe a little extreme. With regard to your question on size, the only way, for instance, if you have a 2-acre parcel in the middle of, say, surrounded by 300-acre parcels that are all agriculture, and the county sweeps that up in its designation, larger area, including this 2-acre parcel, are to be designated IAL, they have the ability to do that. The only time that they would be prevented from doing that would be if that the landowner of that 2-acre parcel had already designated 1.1 acres of that parcel IAL already. The landowner's concern with important agricultural lands, to a certain extent, is based on a perception that at some point in time, the designation will become more important than it currently is. IAL designations do not carry much. I mean, there's a slightly elevated examination of the criteria for determining whether or not you're going to urbanize a piece of important agricultural land than there is on normal agricultural land. But in terms of the uses that may be put to the property, they're no different from what uses you could put regular agricultural land to. So that there's no real change in the use as a result of this designation.
Okay, I can appreciate that, but part of my thought is, and I know there's tax advantages to doing this clearly, which are massive, but if I had only, well, I have 4 acres and I lease 190 acres, but my 4 acres, so in a sense, the government could come in and take over 2 acres of that if they wanted to. And at that point, I would consider it a taking of the land because I'd no longer be able to put an Ohana house on it or something else. But that's what I mean. When you get down to those small sizes, that gets really scary to me, but it's going to be what it's going to be. So no, I can appreciate we need to preserve the agricultural land, and I'm working hard on that myself personally. So thank you very much for the explanations, although sometimes not clear when there's multiple answers to the same question. Thank you.
Thank you, Commissioner Cabral. It is 10:04 a.m. I'm going to call for a 10-minute recess, and we're going to reconvene at 10:14.
Oh, I'm so sorry. As questions come up, something is
Hey.
jotted in my mind. So
That's
this is probably for, thanks. I'm not too maybe this is a procedural question. So are we taking each TMK as an action? Or is this the entire county proposal? I mean, because a lot of the questions we're asking, there's individual landowners. So procedurally, I mean, I'm looking at the county submittal of all of the TMKs. There's hundreds of TMKs. So procedurally, how are we going to take action on the county's requests?
Mr. Ordenker.
Yeah, staff believes that the way this is intended to be handled is that we take the county submittal as a whole. And that if individual landowners have objections to a specific parcel, that we would then take up the county's determination on that individual parcel. But we are not intending to go parcel by parcel.
Commissioner Ohigashi.
Just a this is a legal question, then what is standing to appeal a deck action?
So generally in a deck action, you'd have to declare who the parties are to the deck action. And so it would be whoever was a party to the deck action.
So in this, if just following up on Don's past question, so if there, so are the landowners who object or indicate, are they parties? We're treating this as a deck action.
I would think they would have to be because it's their land that is the subject of the petition. So I think they would have standing.
But would that be required to be in any findings of fact, conclusions of law, that we recognize them as parties? Or is that a rule that we need to establish?
I'd have to think about that. I think ideally you would want to identify them because you'd have to identify the lands that are being classified or reclassified as IAL lands. And so when you do that, naturally you should also be identifying the landowner. And to the degree the lands are subject to the decision, the landowners are subject to the decision as well and would be considered either interested parties or parties to the decision.
Could we have a procedure worked out prior to the hearing of the county's IAL petition, I guess would be for that? Or to clear up, how would that work?
Sure. I mean, obviously we'd want to work with the staff to try to create a process to have this go as smoothly as possible and to try to set everything up ahead of time.
Thank you.
Thank you, Commissioner Ohigashi. Commissioners, are there further questions on this? Commissioner Chang?
I'm not going to say this is my last because as questions. So Linda, procedurally, because I would assume like under the town case, you don't have to be a party to the original action, but you could have, for purposes of standing, you could be an adjoining landowner. So we could have these landowners, but are they appealing the entire IAL's designation or do they just appeal? I mean, how do you bifurcate their particular property if we're going to take this up as one action by the city?
So, generally, if they were one of, several people who are involved in it, when they bring their petition or their action to for an administrative appeal, they would challenge certain findings. And generally, it would be the findings that would relate only to their property. To the degree that findings are not challenged, then they would still stand on appeal. So, in effect, it would be to the entire designation, but it would only be generally with regards to their to the parts that pertain to their particular property.
Okay, all right.
And again, maybe a procedure could be worked out where it might be better to try to subdivide up how these petitions are brought to the commission instead of as one giant petition. Maybe it could be, portions to go first and then next kind of thing, to give the commission a chance to maybe iron out some of the procedural issues on a smaller basis before they take on the lion's share of the lands.
Yeah, obviously you guys have a lot, Dan and his staff with the AGs have got a lot to work out because this, I'm just not really clear. I know what the city did was they took them by, whether we call it mokus, but they took, they looked at different areas. So however best, but I mean, obviously we're raising questions which will hopefully ultimately help facilitate the process. But yeah, there's a lot of uncertainty and unanswered, but thank you. I appreciate the comments.
I think Commissioner Chang, just to comment on your question, the sort of like substantive issue it gets at, one of the substantive issues it gets at is not beyond just notice. If you were appealing, who do you notice? But you know, for agricultural enterprises to be successful in the long term, they often depend on having neighboring agricultural enterprises and sufficient scale in terms of like supporting supportive businesses and infrastructure. And so it's while an individual might want to opt out, it's hard to talk about the constitutional goal of protecting important agricultural lands without looking at actual agriculture as well and how those are interacted. So, commissioners, is there anything further on this item and the briefing for from Mr. Oredinker on this very complex issue? If there is none, we're going to leave this agenda item and go to the final item on our agenda, which is a discussion of the LUC's representation by the Attorney General's office. I, as the chair, requested at the last meeting that this item be put on our agenda to allow discussion by commissioners regarding the representation that the commission receives from the Attorney General's office to assess and evaluate the situation and make any recommendations as a body that might help in how our proceedings are conducted. And with that, I'm happy to open up the floor to discussion among the commissioners. Commissioner Wong?
Chair, not saying the AG's office has been, it's been very difficult for me because, you know, remotely, it's hard for me to, I mean, I see Linda now, I see Bill, I mean, I see all the different AGs, but it's hard for me. I would like to work with one attorney general instead. You know how we had Diane before? Just because, I mean, Linda kind of know my nuances already, but you know, it'd be better if we have only one attorney general to understand each of our nuances and where we're headed for. So to me, I would like to just work with one AG if possible.
Thank you,
so that's all I wanted to say, Chair.
Thank you, Commissioner Wong. Are there other comments from the commission? Commissioner Okuda?
Yeah, Mr. Chair, thank you. I think my own personal view is that, you know, we've kind of delegated to you as the chair and to the executive officer to take the actions that you would believe that are, you know, move the commission's work along efficiently and lawfully. So, you know, I know there's a concern about rotating attorney generals. I can appreciate, you know, the arguments on both sides. I would leave it to you and the executive officer if you folks want to consult with the attorney general or whomever you would like to consult with on this issue to go ahead and do it. You know, again, there's good points and bad points for different ways of handling this. But I think especially when you're dealing with an agency that is more quasi-judicial than anything else, there is a real benefit to have institutional knowledge and institutional memory. And sometimes that institutional memory cannot be reduced simply on a running log on a case, so that even if you have rotating people step in, they can read the log and know what's going on. Because oftentimes we as human beings, I believe, we remember things that we don't necessarily write down because at the time these things are happening, there might not be real significance to them. But later on, when something significant does come up, we reach back into, you know, the memory we have. Hopefully we're competent enough to do that. And that experience, you know, hopefully informs us and makes us better advisors as lawyers to our clients. So I kind of agree with Commissioner Wong that if we're balancing a rotating group of attorneys, and there's benefits to that too. There's benefits to that, but if we weigh that against the benefit, if we have a competent attorney who is primarily assigned to the commission, I think that's in the best interest of the state, especially in reducing liability from future lawsuits or claims. Because let's face it, if we exercise our discretion within the law, usually we won't get into trouble, either an affirmative claim for dollar damages or anything else. I believe the real exposure to government agencies to claims is failure to follow process or procedure. And a good evidence, and in my when I was suing another agency of the state of Hawaii, and I promise you it's been resolved, years ago before I got on the commission, the big deal I made was the fact that when you went to the different bureaucrats, you got different results. And that was a constitutional due process violation. And, that created the problem. So I believe on a whole, having somebody who would be, have the primary ability to have institutional memory, institutional knowledge is a benefit to the state. But I leave it up to you, Mr. Chair, and the executive officer to, to consult with whomever you would want to consult on this. And that's all I have to say. Thank you.
Thank you, Commissioner Okuda. Commissioner Giovanni, you raised your hand, but then lowered it. Oh, you're muted, Commissioner.
Sorry, Chair. Yeah, I raised my hand because I was going to ask Commissioner Okuda to expand on his comments, and then he did it automatically. I didn't have to ask.
Thank you. Deputy Attorney General Chow.
So, yeah, I'd like to explain some of our background and the experience that we bring to the commission. So, right now we have, 7 deputy attorneys general, and we provide advice to the Board of Land and Natural Resources and the Commission on Water Resource Management. So we are used to giving advice to agencies that are involved in quasi-judicial proceedings and decision-making all the time. We do the land board on a rotating basis. And as far as Commissioner Wong's comment about us getting to know the nuances of the commissioners, I think we all get to do that with the board members. We've all had experience with the board members. We all have get to know them very well, both through personal meetings and even in Zoom meetings. And so I think that will come in time. We will, certainly we know some of your tendencies already, and we'll just get to know that better. But I think the real forte in having us staff you the way that we are is that at least 5 of the 7 deputy attorneys general have over 10 years of experience each advising boards and commissions. So we know, sunshine law, we know procedures, and we know, contested cases. We know those types of issues very well. And so we also bring our background in the diverse specialty areas that we work in. One of our deputies is our acquisition guru in the division. She knows how to do acquisitions inside and out using all various means.
Ms. Chow, if I may, and if you are concerned with my cutting you off, you can say just, I want to continue to speak, and I will allow you to do so.
I would like to continue to speak.
Go ahead.
So, I think we have a lot to offer the commission, and frankly, right now, we don't have the staffing ability to dedicate one deputy attorney general to just the LUC. And that really is the bottom line for us.
Commissioner Okuda.
Yeah, Ms. Chow, we all appreciate the budget issues. And like I say, I'm not advocating one way or the other. It's just that I think there are benefits to having somebody whose primary focus is on the commission. And if I can just raise just one point, and I'm not saying this governs in every case, but what I found being on the commission, and I know Ms. Chow, I know you from decades ago from private practice, so I know you come from a private practice background also. And let me preface what I'm about to say. I mean, we are going to follow the law as commissioners without prejudice or without favoritism or fear from anyone. So please don't take this as any predetermination of anything. But after a while, when we as human beings deal with certain people, we get an idea of, I'm not saying who we can trust, but we get an idea based on the body of work that lawyers or planners or other people present to us about the people who we need to delve a little bit more deeper into what's being submitted, and other things which I'm not saying we would shirk our duty or be flippant about it or just be lazy about it, but there are some people who, frankly speaking, and I don't want to say you can rely on them more, but it's a life experience we bring. And so all I'm suggesting is just to please consider, that's all I'm asking, just please consider the benefit that somebody would have, because let's face it, the cast of characters that appear in front of the Land Use Commission, many times it's the same cast of characters. And I know some fellow lawyers in private practice, if they get a judge who they've never been in front of before, and that judge really doesn't know them, there are some lawyers in the practice who believe that they think they can take liberties with trying to get away with things because that judge hasn't dealt with them before. While on the other hand, when you repeatedly appear in front of the same judge, and it's like if you're repeatedly appearing before the same attorney general, there's a human factors thing, which is if you are sloppy in your work, or God forbid you lie, human beings sometimes feel a little bit more constrained, that they don't want a bad reputation. So all I'm suggesting is just to please consider the fact that there might be, this benefit to having somebody more permanent than less permanent. Thank you, Mr. Chair.
Commissioner Axon, followed by Commissioner Ohigashi.
Thank you, Mrs. Chair. I just want to echo Commissioner Wong's sentiment. And for me also, personally, my preference is to stick to one attorney general, which brings us institutional knowledge from previous cases. I wouldn't want, if I'm appearing in a court of law, I wouldn't want different lawyers represent me every time I show up in court. Interestingly, Deputy AG Chow mentioned about each of them has some personal views and personal experience that brings to the table. And sometimes those personal views and personal experience kind of conflict with each other. One, I think, I raised it up with our executive officer about at one point, there were two conflicting opinions given by two different AG. And that's the reason why also I raised it up to our executive officer. I think we should have one AG represent us, So again, and I also want to echo Commissioner Okuda's, that, I kind of leave it up to the executive officer and the chair to work with the attorney general on this issue. But if you ask me my personal preference, that's my personal preference. Thank you, Mr. Chair.
Thank you very much, Commissioner Axon. Commissioner Ohigashi.
I'm in a position where I find myself for the first time being a client. And as a client, I think that we should be able to express our views and choose and have an opportunity to have a hand in determining our representation. Be that as it may, in every attorney-client relationship, I know that there are rough spots. There are difficult things that occur during that relationship. I think that a fruitful way of dealing with this issue need to have our, again, as everybody says, our executive officer and our chairman speak with the Attorney General herself to discuss what as a client we need and what we expect and how that will be delivered more fruitful, in a better manner, as technically we are clients. So I think that Ms. Chow has to speak for her division and her, I guess, her people that are within her division. However, I think that an overall discussion requires to take place between our board and the Attorney General herself, or perhaps First Deputy. That's all I have to say.
Thank you very much, Commissioner Ohigashi. Ms. Chow.
So I just want to respond to Commissioner Ohigashi, and it is always the prerogative of the commission and the executive director to speak to the Attorney General herself. I did actually speak to the First Deputy about this situation, and she actually approves of the way that we are staffing the LUC at this time.
Commissioners, if there's nothing further, I feel that I have a good sense from, Commissioner Giovanni?
Thank you, Chair. I just wanted to weigh in with my fellow commissioners. I found myself in absolute agreement, surprisingly, with Commissioner Wong, not surprisingly with Commissioner Axon and Commissioner Okuda. I would prefer that we have, and I do appreciate the arguments made by Ms. Chow, and I'm sensitive to that as well. But just in terms of functioning of the commission, consistency of how we move forward, I would favor, if we could, to have a dedicated Assistant Attorney General work with our commission.
Thank you, Commissioner Giovanni. Commissioner Cabral.
I agree. It's more comfortable and it's nicer, and I have a feeling of more reliability when I have the same person, because again, as been stated, we have more of a trust or a feel for somebody who we've gotten familiar with. But at the same time, I'm being the, capitalist that I am. If the government could spend less money, I'm going to be really happy. So, so I can appreciate that there are going to be decisions being made, and we're not going to all be as comfy as we might have been before the pandemic, because the money's going to be even tighter. And maybe there should be cuts, even if we get more loans, let's get more efficient. So I would love to have the same person, and I would love it if that consideration could be made when assignments are being given, when the assignments be given out. And maybe that's administratively something in their office they could do is, hey, you're the first person to always go if you're free and you don't have some other massive schedule you've already done. And Linda, you're great. So be on the top of the list for us, and then come on down, and then we'd have the second person. So maybe administratively, instead of it just being this, just send anybody, you know, it could be some kind of a better priority on how your folks' office operates and administratively sends people. But, you know, I'd love to have the same person, but I can appreciate that that may not be the most costly and efficient. So thank you.
Thank you, Commissioner Cabral. Is there anything further, commissioners? If not, I have a sense of where my fellow commissioners are. That gives me a good feeling with the kinds of issues we can raise with, along with Mr. Ordenker to the Attorney General herself. I will say that I am appreciative of all my commissioners' comments as well as the responses from Ms. Chow. For me personally, this issue came up after a few incidents, one where I was having to correct the Attorney General on points of law, which I think was an effect of having them rotating through, as well as a couple incidents which I can only fairly qualify as outbursts, which I think were partially a result of the rotating. So it's a concern. We're happy to have a productive and useful discussion about it, and I thank you for your indulgence in considering this agenda item. Mr. Ordenker, is there anything further on our agenda?
No, Mr. Chair, there are no other matters on the agenda for today.
Okay. Seeing nothing further, I declare this meeting adjourned. Thank you very much.